Hello, everyone, and thank you for joining us for today's webinar. My name is Carolina Grimberg Golijov, and I'm the Human Rights Law and Research Officer at the Jerusalem Institute of Justice. The Jerusalem Institute of Justice has been hosting several webinars, both to provide updates on the current situation and also to analyze some of the legal aspects of the war. And we are delighted to collaborate with ALMA for this special webinar between conflict and compliance, the loss of war in the Israel-Hamas hostilities. The Jerusalem Institute of Justice, JIJ, is an Israeli legal and research institute that holds special consultative status at the Economic and Social Council of the United Nations for its contribution to the promotion and protection of human rights in Israel and in the Middle East. The International Law and Public Diplomacy Department actively engages with the UN, its special procedures bodies, the ICRC, the EU, and other states and institutions to advocate for the respect of international law. In line with our dedication to collaborative initiatives promoting awareness and respect for international law, JIJ has partnered with ALMA, the Association for the Promotion of International Humanitarian Law, to co-host this insightful webinar. ALMA, established in 2010, is an apolitical non-profit association dedicated to enhancing awareness of international humanitarian law, IHL. ALMA's primary goal is to make IHL knowledge accessible to all and to nurture discussions on its significance and practicality. Now I would like to introduce you to our distinguished speakers, Dr. Daphne Richemond-Barak and Dr. Ido Rosenzweig. Dr. Daphne Richemond-Barak is an assistant professor in the Lauder School of Government, Diplomacy and Strategy at the Reichman University, Israel, where she heads the International Program in Government. She also serves as an adjunct scholar at the Modern War Institute at West Point and as a senior fellow at the Institute of Law and Land Warfare. Her research interests include human security, contemporary warfare, and the future of international order. Her monograph, Underground Warfare, was published by Oxford University Press in 2018, and she is the author of the 7th edition of Rosen's The World Court, What It Is and How It Works. Dr. Ido Rosenzweig is an expert in international law with a focus on international humanitarian law and human rights. He serves as the Director of Research in Terrorism, Belligerency, and Cyber at the Minerva Center for the Rule of Law under Extreme Conditions at the University of Haifa. Concurrently, he holds the position of chairperson at ALMA, the Association for the Promotion of International Humanitarian Law, non-profit organization based in Israel. Dr. Rosenzweig provides pro bono advice to the Hostages and Missing Families Forum as part of its international law team. Ido has over 15 years of extensive experience that covers roles in think tanks, NGOs, academic teaching, UN consultancies, and providing legal advice. His PhD focused on the right to life of combatants under international law. Today, we're going to discuss how international humanitarian law or the laws of war apply to the recent and ongoing events that are taking place in Israel and the Gaza Strip. As you probably know, on October 7th, Hamas terrorists launched a brutal attack in Israel, marking one of the darkest days for the Jewish people since the Holocaust. Now, after 45 days, there are 236 individuals that are still held hostage in Gaza. Over 5,300 people have been injured, more than 1,400 lives have been lost, and more than 9,000 rockets have been launched into Israel from the Gaza Strip. I will now proceed to the discussions with our speakers, and following that, we will open the floor for a 10 to 15-minute Q&A session. You can all leave your questions at the box of Q&A that is here available at the Zoom. So I would like to start explain a bit what IHL is for those who don't know. We've been hearing a lot this mantra of that even wars have rules, and that is indeed true. There is a body of rule that regulates armed conflict, which is the International Humanitarian Law, IHL, also known as laws of war. This set of regulation seeks to limit the effects of armed conflict by protecting individuals who are not taking part in the hostilities, and also by regulating the means and methods of warfare. So my first question for you, Dr. Richemond-Barak, do you think these rules apply to Hamas, or under IHL, do these rules apply to Hamas, which is not a state?
Thank you very much. It's a pleasure to be here tonight with both of you and with everyone else who's joined us for this webinar. The last 45 days have been very, very grueling and difficult for many of us here in Israel. And I'm glad that we'll have you tonight to discuss some of the legal aspects of this operation, and maybe also about the massacre of October 7th. The law of war, which you define very eloquently, Carolina, they are a set of rules that govern the conduct of all actors in situations of violence and armed conflict. And these rules, even though they were drafted originally by states in multilateral large treaties that, some of them are very well known, like the Geneva Convention of 1949, some of these norms are, and especially those that are kind of very well entrenched and uncontested. For example, the rule that you cannot direct strikes intentionally at innocent civilians. These rules are applicable to all actors, including to Hamas, even though it's not a state. So to be honest, this is I'm stating this as a truth because it really isn't a contested statement. It's very much accepted by all. There are different legal theories that explain why that's the case. But without going into these details for now, the point is that the basic rules of international humanitarian law that protect civilians in war in particular are applicable to all actors, including Hamas.
Thank you. Dr. Rosenzweig, is there something you would like to add to that?
Well, other than saying thanks for inviting me, and well, I'm part of ALMA, so I'm inviting myself as well here. I think I agree completely with what Daphne said, and I think it is important to understand that the essence behind international humanitarian law is to regulate the conflict, to regulate the war, and at the same time minimize the damage to uninvolved civilians and sometimes also to combatants. And the idea is to limit the harms of a conflict. And the only way to do it is if all sides are obliged by the same set of rules, and especially the core rules, as Daphne has mentioned. Yeah.
Thank you. So I think, and I would like to ask you, if now that we stated that Hamas has to comply with IHL, do you think it has committed violations of IHL? And what are, in case yes, what would be the legal repercussions for Israel if and when the laws of war are violated by Hamas? Dr. Richemond-Barak.
I think I'm going to leave this to Ido in a second, but I want to just go back, kind of like linking between those two questions that we've been looking at. I think it's important to also emphasize the rationale behind the laws of war. I think regulation is definitely key, and it's very, very important. But there's also this idea that in war, the end doesn't justify the means, meaning that there could be that in war, it's axiomatic that the goal of the belligerent is going to be to win the war. And that's something that the law of war totally accepts and acknowledges and even addresses at length. But nevertheless, what the law of war does is that it seeks to balance that out with the humanitarian, the kind of harm that is going to be caused to the civilian population as a result of the war, and to protect vulnerable people from that as much as possible. And so this balancing between the need or the desire of states to win wars versus the protection of vulnerable people, this is at the core of what the international humanitarian law or the law of war, these are basically interchangeable expressions, but they reflect the two prerogatives or the two imperatives that we're trying to achieve here. So the idea is that, yes, you've been maybe the victim of an atrocious attack. Yes, you need to respond to that and make sure that this is not going to happen again. And we'll talk about this later. But the point is, not everything is permitted to that end, and there are constraints. And I think even in this really difficult hour that we face here in Israel, it's important to remind ourselves that this is the case. And yes, sometimes it's going to slow down the forces, and yes, sometimes it's going to limit what can and cannot be done. But I think we owe it to ourselves to also remember that, and so that's something that I want to make to mention. And now I will leave it to Ido to talk about the violations of Hamas, because I think he has them quite organized in his own head.
Yeah. Well, to be honest, almost everything Hamas does falls under a violation of international humanitarian law, and most of it is even grave breaches of international humanitarian law, which qualified as war crimes. And the list is, just to mention a few of them, we can go on the notion of taking hostages, directly attack against, conducting an attack directly against civilian population, indiscriminate attacks against, well, indiscriminate attacks at all, generally. Sexual gender-based violation is also a grave breach and a war crime, and the use of human shields is a violation. Operating from within hospital is a violation of international humanitarian law. The list is basically, if you go over Article 8 of the Rome Statute, which provides a good list of most customary and agreeable war crimes, you can almost do a checklist of all the crimes that all the actions taken by Hamas, and see that a lot of them qualifies as war crimes. And therefore, it is important to understand that there is a difference, especially when we look at war crimes, when we look at violations of international humanitarian law. There is a difference between the blatant violations, which are clear-cut violations. When they have been done, it's a clear violation. For example, attacking civilian intentionally, directing attacks against civilians is a clear-cut violation. There is no doubt when you go from house to house and you kill civilians, when you go to a nature party and you kill the people, the civilians who are participating in the party, these are direct attacks against civilians. When you use indiscriminate attacks using rockets towards basically the entire half of Israel, then these are clear-cut violations. And on the other hand, the other type of violation is the violation that requires more information and is based on either the judgment and the discretion either of the commander or the combatants in the field. And these are when you want to know when a certain object has been the subject of attack, was it a civilian object or a military object, then you need to know what information the attacker had at the time of the attack. When you want to argue that an attack was disproportionate, which means that the collateral damage from the attack, the anticipated collateral damage from the attack, was excessive towards the expected military advantage from that the same attack, you need to know what information, what intelligence the commander had at the time, and what was the evaluation between the military advantage and the collateral damage. So there are violations that are clear-cut, and you can clearly see that there are violations of international humanitarian law, and there are violations or alleged violations which require more information. Hamas actions are within the first part. The blatant violations, the ones that you don't need any more information in order to qualify it as a war crime and leave it by that. And so you ask what are the ramifications toward Israel by the fact that Hamas has committed war crimes? That was the second part of the question?
Yes.
So as the main idea is that the fact that one side violates international humanitarian law doesn't allow for the other side. There is no reciprocity in international humanitarian law, and therefore the fact that Hamas is conducting war crimes doesn't allow Israel to go even one step lower than the standards that international humanitarian law require. Other than that, Israel has the obligation to get control, and if it has the ability to also punish and to trial Hamas members that has been caught by Israel. So other than the ones that Israel is going to kill in the course of the conflict, if Israel has managed to capture, to hold, to detain members of Hamas who have participated in the operations, it has the obligation to try them for their crimes.
Thank you. Thank you both for your answers. So, Dr. Rosenzweig, you raised the issue of proportionality, this concept that has been used lately a lot. Particularly, it's used in reference to Israeli actions, although, as you said, Hamas has committed clear violations of IHL. But unfortunately, these terms, besides of only referring to Israel many times, is also misused in the sense that they claim that, for instance, there are disproportionate military actions based only on the casualty numbers from each side. But as you said, actually proportionality, it's not what it means. Proportionality assesses the incidental harm inflicted on civilians in comparison to the anticipated military advantage gained from the attack. So, Dr. Richemond-Barak, could you please develop on what criteria determine whether an action adheres or not to the principle of proportionality, and how does it apply in the current war?
Sure. I think the concept of proportionality is probably the most often misunderstood and misconceptualized concept of IHL. That people use it without knowing what it means. Journalists use it a lot without knowing what it means. And this could just, you could just blame it on ignorance, and it could, we could just say, oh, we just need to educate people. But I think it's a much deeper problem, because the problem with international law, I mean, it's not a problem, but in this case, it is a problem. In general, it's not. International law evolves and changes when people, when the interpretation of the concept evolves and changes. And so if the concept becomes, kind of uniformly misunderstood, then this can actually change the concept itself. So we need to be very careful here in maintaining the integrity of the concept of proportionality. To me, this is a key objective of even my own personal work and our work as academics and practitioners of this field. It's very important. What am I trying to say here? There's this idea that somehow war, which is a brutal, tragic reality in and of itself, but nevertheless regulated by international law, that war could somehow be waged with zero casualties. And that the goal, that all states waging war should be, striving towards, but also implementing, would be to actually not kill any civilians in war. And this already is a misconception of what war is all about, and also what IHL is about, because IHL does acknowledge, actually, and this acknowledgement comes in the shape and form of the concept of proportionality. International law acknowledges that in war, innocent civilians will die and will be injured, and that civilian infrastructure will be destroyed. This is very uncomfortable to say, and this is why not very many people say it, but this is what IHL says. In fact, some people criticize IHL for saying that it justifies or legitimizes the killing of innocent civilians. And that's because it does contemplate it, but then it regulates it, right? It contemplates it and says, okay, innocent civilian will be killed because this is the nature of war. There is a fog of war, things happen, mistakes even happen. So how can we minimize that is what IHL asks, really. And so it creates a balancing test, which you described and which we'll elaborate on just now. But this is at the core, again, of these competing objectives that IHL seeks to reconcile between, on one hand, having to win the war, wanting to win the war, and on the other hand, minimizing the amount of civilians that are going to be hurt incidentally, not intentionally, incidentally, because intentionally, of course, that is prohibited. So what does the law say? The law says that a strike will be disproportionate if the harm caused to civilian infrastructure and civilians themselves is excessive in comparison to the military advantage that is anticipated from the strike. In other words, how much closer does this strike bring you to victory? How important is the target that you are striking? And the more, I mean, basically, if you translate this a little bit and to try to put it in a different way, the more important the target, the more valuable the target in military terms, and the more IHL, the higher amount of civilian harm IHL will, again, tolerate. It's not that it encourages it, it tolerates it. So the higher the military value of the target, the higher the collateral damage that is tolerated by the law. What this means is that the law tolerates a certain amount of civilian death and casualties. Again, not a very pleasant idea, but the reality of war is such that this is what the law says. And it's only when it's completely imbalanced, when one is excessive in relation to the other, that we're talking about proportionality. And so this is the concept of proportionality really in a nutshell. But the point is that, kind of like, again, turning it on its head, you could say that if civilians get killed in war, it means that a war crime was committed or that the strike was disproportionate. And that is this is jumping to conclusion, because what you really need to do is an analysis of what was the target, what precautions were taken in order to minimize the harm to civilians, and then determine whether the harm to civilians eventually caused was excessive in relation to the military advantage. And that's a complicated and subjective test, which, takes a while to explain. And it's very kind of like, I could think that something is not excessive, but Ido could think that it is. We could totally disagree about this if we're military commanders. But the point is that the law tells us how to think about it and what to do about it. How do we choose the target? What kind of weapon we use? What kind of advance warning do we give to civilians? So it's a process of decision-making that the law imposes, but it tells us that ultimately, yes, it's a subjective test that depends on the human being that's making the call.
Thank you.
And I would like to add one point to that, is that as Daphne mentioned, the fact that the concept of precautions, and the concept of precautions, which the implementation of proportionality is within that. It is one of the precautions and the requirement to cancel a disproportionate operation or an attack, but it also, another aspect of precautions require us to aim for the lowest collateral damage possible that we are able to, by giving warnings, by using more accurate weapons that are available under the circumstances. And this is a complete framework that requires to refrain from collateral damage if possible, but if we cannot refrain from that, to minimize it. But once we've done everything we can under the circumstances, which is a very important caveat within international humanitarian law, that you have to take into account the circumstances available at the time. Once you've taken all precautionary measures available under the circumstances at the time, then collateral damage is permitted, as long as it's not excessive towards the military advantage. And one more point that we need to address within the concept of proportionality, and Daphne said it briefly when she talked about the equation. The equation refers to anticipated and expected, and not the actual de facto outcome, which means that if my intelligence and my understanding of the circumstances of the situation was that for an attack, important attack, after all precautionary measures, I'm aware of, let's say, just through a number, 10 people, 10 civilians will be collateral damage. But in fact, there were more civilians there that I didn't know of. Then, in accordance to international humanitarian law, I'm being analyzed in accordance to the 10 that I knew of, that I anticipated, and not about the 20, 30, 40 that actually happened. And this is, for the press, for the media, for anyone outside of international humanitarian law, is very hard to understand. Why are we talking about what happened, what was anticipated, and what actually happened? So when they're talking about actual damage, people care about 40 civilians actually died for an action. But international humanitarian law will only calculate 10 of them when you evaluate whether or not the operation was proportionate or not. And this is a gap that it's really hard to grasp if you don't come from within international humanitarian law. And the last point within that point is that the discretion is not of the lawyers. It's not for the politicians. It's not for the cabinet members. The discretion is of the military commander who orders the operation. And only that person, that commander, is allowed to make that discretion and say, okay, my evaluation that this is proportionate or this is excessive, and act accordingly. It is very important to realize that these are not lawyers that gives you the go on such an operation. It is a military commander that has been trained, has the experience, has the knowledge to make such an evaluation.
Thank you. And actually, from what you mentioned also, we have to take, or those who, for instance, the army has to take into account the circumstances, right? And we know that in this case, it's very known that Hamas uses human shields. So how does this interact with the proportionality principle and also with avoiding civilian casualties if you're facing an opponent who actually uses civilians to protect themselves? So Dr. Richemond-Barak.
Sure. This is one of the war crimes that Hamas commits that we spoke about earlier. This can be very difficult for people to understand. The fact that when you are fighting an enemy that not only does not respect the laws of war, but also makes a cynical use out of them, meaning kind of like uses to its advantage the fact that you care about the law of war, and that can be very difficult to understand, that you're still obligated by those rules. And this is what we opened this webinar with, but here it comes up again, right? So Hamas uses human shields. That is a war crime. That is a cynical use of the law of war, because again, they use the civilian population to immunize targets from attack. That is prohibited under IHL. But the problem is that it constitutes a war crime, but it does not change the obligations of Israel. And Israel will still have to make sure that it takes all the precautions to not maim incidentally civilians in a way that would be excessive to the military advantage that is anticipated from the strike, as we said before. And the fact, Hamas, Hamas is not the only terror organization that does that. But what it does is that very commonly it puts civilians on top of a building. The building it knows is about to get struck by the IDF, and then the IDF at the last second sees all of these poor innocent civilians being used as human shields, and then has to basically cancel the strike. This happens regularly, and it's I think an illustration of what it means in practice to abide by the law even when your enemy doesn't. And this can be hard to swallow. It's a tough one to swallow, and it's very often it's cumbersome. And if we try to translate that into today's battlefield, what we see is that Hamas has made use of medical facilities in a way that essentially, you're talking about human shields, essentially what it does is that it uses those medical facilities as human shields, as gigantic human shields, as it's like the perfected art of human shields, right? It's like this is the most protected site under international humanitarian law. Israel has shown that it is not willing, it was not willing until now to target them or to tackle this problem, because it is a very sensitive and serious one under IHL. And so let's put all of our military assets behind those shields. That's the essence of a human shield. And yet, what do we see? We see Israel giving evacuation of the hospital, and we see Israel going with really with an operation that again is very sensitive and definitely has its downsides. But the point is, could Israel have simply targeted the hospital without taking, just on the ground that this is a human shield? Of course not. This would be a violation of international humanitarian law, a gross one. So human shield used to be a concept that we referred to when we talked about these civilians on top of a building. But the truth is that the medical facilities are also a sort of human shield. And I'll tell you about the third example, contemporary one of human shield. Putting Israeli hostages inside the tunnels of Gaza is also using them as human shields. Because then what it means is that Israel will think twice about targeting what is actually a military target, those tunnels, right, that serve as ammunition cache and command and control centers for Hamas, because it knows that its own civilians are there. So the point is, what we see is the concept of human shields, which began with people being on top of buildings and actually worked, has now been extended and implemented in a whole variety of contexts in this gigantic idea of human shields, but nevertheless, Israel is still committed and abiding by the law.
Thank you. And Dr. Rosenzweig, before you add to that question, in addition to this question, I would also like to add, because Dr. Richemond-Barak also raised the issue of hospitals, and it's worth to mention that according to the laws of war, hospitals are actually entitled to special protection. But there are situations in which hospitals can lose this protection, right? So I would like to know also if you could add on the previous question and explain how does this works, like how is this protection gets lost with hospitals and other civilian buildings?
Of course, thank you. Well, with regard to the previous question, I think it's also important to understand that human shields, generally speaking, are not taking direct participation in hostilities. They are not considered taking direct participation in hostilities, and therefore they are collateral damage. They are not considered legitimate object of attack. They are collateral damage. And there is some minor discussion whether or not voluntary or involuntary human shields would constitute taking direct participation in hostilities. But even voluntary human shields would have to actually act very actively and take a very direct part in the hostilities, and not just be human shields, even if they are doing voluntary, in order to be considered legitimate object of attack and not collateral damage. And even within that, I know that most, if not all, active military forces are saying that if they don't know if the person is doing human shield voluntary or involuntary, they have to assume that this is involuntary, because you don't know if, for example, how Hamas is forcing them to participate, and therefore they are to be considered collateral damage. With regard to the hospitals, one sentence before that is that in accordance to the Geneva Conventions and the additional protocols, there is a very important clause that says that the presence of protected persons, the not legitimate targets, collateral damage, will not make a specific target immune. So if a target is a legitimate military target, and in a second we're going to talk about what is a legitimate military objective, then the presence of civilians will not make it immune from attack. It will move to the question of precautionary and proportionality, etc., in order to decide if you're allowed or not allowed to actually attack it. But the military objective remains a military objective, even if there are civilians within it or around it. It's very important to understand that there is no immunity from the presence of civilians in an object. Now, with regard to hospitals, hospitals are, generally speaking, considered a civilian object, and civilian object will only be allowed to attack if it transfers and becomes a military objective. And one of the only articles that I can actually quote by number in international humanitarian law is Article 52.2 of the Additional Protocol 1, that says what is a military objective and what is a civilian objective. And a military objective is an object that by its nature, location, purpose, or use offers services or advantage to the military, to the adversary, and its destruction provides advantage to my forces. So when we look and try to understand if a hospital transfers from a civilian object to a military objective, we need to understand if it's either nature, location, purpose, or use provides us any military advantage. It's being used basically by the adversary. And in the case of Hamas, hospitals are being used by Hamas, and therefore either for the entrance for tunnels or to hide ammunition, or as we've seen in the IDF spokesperson's updates, they are actually being hidden within the personnel of the hospital, and therefore the hospital becomes a military objective, or at least the parts of the hospitals which are being used. We can't address the entire compound as one target. Every section that is being used by Hamas has become a military objective. And from that point on, it is a legitimate object of attack. However, we still need to take into account relevant precautions. And the most important precaution with regard to hospitals is the advance warning. Advance warning means that whenever you attack a military objective that expected to cause damage to the civilian population, an advance warning must be given. And this is a very important precautionary measure. And there are some caveats when you're not obliged to provide such an advance warning. One of them is a surprise attack. Another one is when you're doing a responsive shooting. So when the circumstances don't allow you to provide an advance warning, you don't have to give an advance warning. This is a very practical caveat within the notion of precautions in order to make sure that states still can actually fight. So the international humanitarian law remains practical for states. Otherwise, if the moment IHL becomes impractical, it will lose its legitimacy and states won't oblige to it. So in the context of an advance warning, we have these caveats of under the circumstances, you need not to give an advance warning. However, hospitals are the caveat to that caveat. Hospitals must receive advance warning, an effective advance warning before being attacked. And that advance warning has to give sufficient time to evacuate the hospital from personnel, from the patients, and sometimes from relevant equipment before striking the hospital, or alternatively, allow the adversary to stop using the hospital for military purposes and therefore stop remove the necessity to attack that hospital. Unfortunately, within our circumstances, within Hamas operations, the entrance to the tunnels, the use of the hospitals for other military purposes cannot be stopped. They cannot suddenly unlock and block all tunnels. And on tunnels, we have, Daphne is much bigger expert than I am, which we'll discuss later on. But the notion of the entrance to the tunnels, the notion of the use of Hamas, the ongoing, continuous use of Hamas of the hospital makes it a legitimate military objective. And therefore, following all the warnings and giving the time to evacuate, Israel is allowed to conduct an operation against the hospitals. After all that, we need to also remember there is another precautionary measure of minimizing collateral damage. And sometimes it means to take a higher risk on your own combatants, on your own soldiers, in order to minimize potential collateral damage. And the implementation of that is the fact that the IDF doesn't strike the hospital from the air. It doesn't strike it from far with any ammunition. It sends its own forces, ground forces, into the hospital in order to make sure that patients won't be harmed, that medical personnel won't be harmed, and to minimize, and I think to this point, unless I've heard something wrongly, IDF has managed to enter both hospitals so far with no collateral damage, which means full implementation of all of the IDF obligations under international humanitarian law. Give advance warning, give time to evacuate those who can evacuate, and then send your ground forces into the hospital, knowing that you're probably risking your ground forces in order to make sure that you are operating and minimizing collateral damage. And we can conclude that point with Daphne's last example of the human shields, that Israel has some obligation towards its own citizens and civilians, the hostages, and therefore it will take even a higher risk sometimes for put higher risk on its soldiers in order to make sure that they won't mistakenly harm the hostages.
I want to add something here about the operational cost that these precautionary measures might have at times, and might, in a way, it has to do, here we're talking about kind of the implementation of IHL. I want to address that for a second. A lot of people around the world are getting, I'm using my words carefully, but I think really this is what we're hearing, a lot of frustration. People are getting frustrated with the fact that the IDF is not uncovering all the tunnels around and in the Shifa hospitals and the other hospitals fast enough, or is not providing enough proof fast enough that the medical facilities were indeed used for activities that were harmful to the enemy, and as such lost their protection under humanitarian law. But the fact of the matter is, let's think for a second, about this advance warning that was given and was, I'm not questioning that for a second, but I want to reflect on what are the consequences of advance warning in such a situation. When Hamas knew very, very well that Israel meant to conduct its operation in the Shifa hospital. Israel gave warning. It was a build-up of about 2 weeks. Israel brought a few pieces of information, and the idea, was also to explain legally why this eventually would become, a legitimate a military target that can be struck in some way by Israel. So what happened when Hamas found out about this warning? Well, Hamas concealed everything that it had in the hospital and probably sealed a lot of the tunnels, making it very difficult for Israel to now find them. So they're already hard to find. But I'm mentioning this because I want us to really take stock of what it means to give advance warning. Yes, it enables, of course, patients to be evacuated to different hospitals. Yes, it minimizes the harm to the civilian population, but there is a cost at the operational level as well. And this is the whole balancing, right? Again, I think it's important to constantly return to that. The balancing between minimizing the harm to the civilian population, but understanding that at the operational level, there is a cost by telling your enemy, 2 weeks before you're actually going to come and do a ground operation in a hospital, that this is what you intend to do. The warning could have been given, by the way, closer to the time where the operation was going to take place. It did not, but this actually is also one of the reasons why right now it's taking Israel some time to get through with the work that they have to do there.
Thank you. Yes, you both have raised the issue of the tunnels also, which is, we talked about the civilians, we talked about the civilian infrastructure and buildings like hospitals. Also, we know schools and mosques have been used by Hamas for their terrorist purposes. But there is this entire underground structure beneath all of these civilian buildings and densely populated areas. And we know that parts of the tunnels are even concrete reinforced. They're equipped with electricity. They have even food and water. And they're even large enough to host gatherings of people. And even they allow vehicles to travel through them. And as you said, there is also the concern that tunnels are being used to hold the hostages. So Dr. Richemond-Barak, I know this is, as it also mentioned, your expertise. So you mentioned some of them, but how can you develop a bit more on how is this structure of the tunnels and how is it being used by Hamas? And also what are the challenges of Israel and the IDF when facing this type of warfare element?
Sure, I'll try to make it short because I could talk about this for hours, as many people here know. But let's just, describe them very briefly, and then I'll talk about some of the things that are going on right now. So the tunnels of Hamas, they are work in progress for the last almost 2 decades. Hamas has integrated tunnels into its strategy. It started with smuggling tunnels, that then went into kidnapping when Gilad Shalit was kidnapped, and then eventually cross-border tunnels, which we saw mostly during Operation Protective Edge in 2014, and also Operation Guardian of the Walls in 2021. But over the last few years, Israel has spent less time thinking about the tunnels inside Gaza. And those really grew with time. And Israel kind of inflicted some blows to these tunnels in 2014 and 2021. But the point is that Hamas continued to dig and continue to build and eventually use the tunnels for more and more of its strategic objectives. So it could be to make ammunition, store ammunition, be able to sustain life underground for a long period of time, which is something that very few armies or even human beings would be capable of doing. And so Hamas exploited this very strategic terrain to its advantage. But let's go back to HL for a second. The problem with the tunnels is that they are hard enough to contend with when they are located in mountainous areas. Think about the mountains of Afghanistan or the mountains of Mali. And now bring those tunnels to a civilian populated area. And so what we see here is a mix or convergence between urban warfare on one hand, which is very difficult in and of itself and raises a huge amount of dilemmas, legal dilemmas and operational dilemmas. How do you go house to house? How do you evacuate, not evacuate? How do you minimize the harm to the civilian population when you wage war in an urban terrain? How do you make sure that you don't destroy the entire city, which is, by the way, impossible in urban warfare? So this whole package of problems, and then on top of that, you take the subterranean and the tunnels that have come so close to people's homes, boring under their homes, their schools, their mosques, UN facilities, and even medical facilities, which is something that has been known for a very long time, including Shifa, but was exposed by Israel only recently. So what we see is that the construction of these tunnels under civilian populated area is in and of itself a violation of IHL, and the people that it threatens are first and foremost the population of Gaza. And by the way, I want to tell you, in 2019, there was an article published by the New York Times. They interviewed some of the civilians that live, the Palestinians who live in Gaza, and they know, of course, that there are tunnels under their homes, and they were petrified. They said they were so scared of these tunnels. So this is 2019. So imagine fast forward to now when it's only expanded and the tunnels are deeper and better. So what we see is that Hamas really relied heavily on this subterranean underground structure. And this, what we see now is Israel trying to find a way operationally to respect the law of war while neutralizing and destroying this structure. And just in just one word to conclude this, what we see that Israel is doing right now is that it has evacuated the population from northern Gaza. It has cleared and cleaned the terrain in order to be able to identify tunnel access points. So you use a bulldozer for this, and you you have to clear the terrain because otherwise you can't find the entrance points. And then it has, and then it is actually starting to conduct some operations at the surface in order to expose the tunnels and eventually also get there and maybe rescue the hostages, get to the leaders of Hamas, and all of that slowly in order to not only achieve military gains but also to minimize the harm to the civilian population. And it's a very tough act.
Thank you. Yeah, I think that what you mentioned now, also the fact that Hamas, no, I don't think only knowingly, but it also willingly, it puts its own civilian at risk. It's not only attacking Israeli civilians, it's also their own civilian population by making this use of human shields and tunnels and the use of hospitals, schools. So I think it's also important to mention this because sometimes, sadly, people forget to focus on that point, right? So we also talked about the hostages and the fact that hostages are probably being held in the tunnels. And we know that the taking of hostages is prohibited by the laws of war. And there is also a term in IHL that it's the prisoners of war, which are defined as members of the armed forces who have fallen into enemy hands. And we know that among the 236 hostages, there are IDF soldiers. So, Dr. Rosenzweig, could you explain to us if the term of prisoners of war or POWs apply to these soldiers, and what is the status of the hostages that are being held captive in the Gaza Strip in general? What's their legal status?
Okay. This seems to be both a simple question and a difficult question, but it has several layers into it. The first layer is, how do we classify the conflict to begin with? Do we classify it as international armed conflict, which is usually interstate conflict, or do we classify it as a non-international armed conflict between a state and a non-state group? There are also some different interpretations for that. For example, the Israeli High Court of Justice in the targeted killing case in 2006 concluded that the conflict between Israel and Hamas is international conflict because it's a cross-border conflict. So even though it's a state versus non-state actor, it is international because it crosses borders. And to that extent, it's important because the notion of prisoners of war only exists under the framework of international conflict, and it doesn't exist under non-international conflict. That being said, that was the complicated part of it. The simple part of it is that it doesn't really matter how you classify the conflict, because Hamas is not a state. It's not a state armed force, it's a non-state armed group, and as such, it has no legitimacy to hold prisoners of war. So if we go into international armed conflict, we have combatants, they have immunity, they have rights, and they also have the prisoner of war if they are being captured by adversary state forces, not by a non-state armed group. In a non-international conflict, we don't have that status, we don't have that framework, and therefore there is no question of prisoners of war. So if you had gone to the classification question, and I've seen in the Q&A, some people have asked about the classification of the conflict, so we have different ways to address it. At the end of the day, I don't think that the classification of the conflict it matters that much to the day-to-day warfare, because most of the rules, if not all of the relevant rules of conduct of hostilities, are customary in nature and apply both in international and non-international conflict. The question of combatants and prisoners of war might have been relevant if Hamas would have been a state actor. But since they are not a state actor, that's because they are a non-state armed group, every person they hold is an abductee. And once they are being held, and they are being held by Hamas in the context that we have, they are hostages. And holding hostages is completely prohibited. It is a war crime. It is prohibited under the Common Article 3 to the Geneva Conventions and Additional Protocol 1 and Additional Protocol 2. It is considered a war crime under the Rome Statute, and to the level and magnitude that we have within the context of that, it also falls into the crimes against humanity of enforced disappearances of the person being held. So I would say to your question that there is no difference between the civilians and soldiers that have been taken by Hamas. All of them are hostages. And I would add to that, that apart from the over 240 that have been captured by Hamas and they are hostages right now, there are two more hostages that we don't hear enough about. And these are Avera Mengistu and Ismail Sayed, who are being held. Avera Mengistu is being held by Hamas for 9 years now without being given a chance to visitations from the ICRC. And Ismail Sayed is being held by Hamas for 8 years now. And they have to be mentioned just as well. And every deal to release them must include Avera and Isham just as well. So to your question, there is no difference between IDF soldiers and civilians being held by Hamas. All of them are hostages, and they must be released immediately. And more than that, pending their release, they must receive proper treatment. They have to receive food, medicine. They have to receive water. There are babies there. There are infants there. According to the information that we have, a baby was born in captive, and they must receive visitations by the ICRC, which Hamas doesn't provide them, and Hamas hasn't provided that to Gilad Shalit when he was hostage by Hamas, hasn't provided that to Avera Mengistu and Isham Isaid. And these are all violations of international law, but the first and foremost is holding them hostage is the big violation and a war crime. And as I said, this also falls under the crime against humanity of enforced disappearances.
Yes, I think it's very important what you said. All the hostages have to be brought back, and also this includes Avera Mengistu and Isham Isaid. Now you also mentioned that regarding the hostages, Hamas should provide water and food and medicine, which we know that it doesn't. And this kind of relates to another question that I would like to ask you is on the side of Israel, right? Because we also hear a lot about this alleged if Israel has an obligation to provide humanitarian aid with like water, fuel, electricity into the Gaza Strip. So Dr. Richemond-Barak, if you could tell us if, in your opinion, do you think Israel is actually required to provide or allow the provision of humanitarian aid under IHL?
Okay, so they're about the provision of, look, Israel has been providing minimum amounts, and actually there are minimum amounts, but there are good amounts of water and electricity to the Gaza Strip in the recent years. There was a decision by the Israeli Supreme Court that actually was a bit weak on legal grounds, but on ethical, I want to say moral grounds, was very strong, which said that if you were once the occupier and you have a relationship with these people who are living in the Gaza Strip now, and you're no longer the occupier, but if they have certain needs that you can actually provide them with, then provide them with the minimum humanitarian needs. And Israel did that. Israel provided these minimum humanitarian needs for many, many years. Now, if you don't really have a legal obligation because you're no longer the occupier, and there is no such post-occupation legal obligation actually doesn't exist, but this is one that Israel kind of took upon itself. And then you're the victim of a horrendous attack of the kind that Israel suffered on October 7th. I think that it's kind of it is to be expected, and I don't know that any state around the world facing a similar situation would do anything differently. That you're like, okay, until now I was doing this, out of a moral obligation and because this is the right thing to do, but now I'm not going to be doing it anymore. Now, I think that's something that Israel can do. However, there is another aspect to that, which is the facilitation. Israel has an obligation to let humanitarian aid enter the Gaza Strip. So even if Israel does not provide it itself, which in my view is not a violation of any obligation on the part of Israel, however, Israel does have an obligation to let this aid come through, the border with Egypt, for example, and let humanitarian organizations come in and provide this need. Now, if we're talking about medical supplies and we're talking about food and we're talking about water, it's one thing. But now we need to talk about fuel. And fuel is something that is very problematic because Hamas relies on the fuel to actually have oxygen, ventilation, and electricity inside its network of tunnels. Nevertheless, Israel has been letting, thousands of liters of fuel every single day in the Gaza Strip, even though it knows where the fuel goes, and even though it knows that this could prolong the war. But again, this is slightly besides the point. The point about the legal obligation, I made it, and maybe Ido wants to add something to that.
Yeah, I think Daphne said the most of it. Article 23 of the Fourth Geneva Convention said that a state has to facilitate, has to enable the entrance of medicine, water, and food into the area. Now, there is an ongoing discussion if under modern circumstances and the ability to operate medical equipment which requires fuel, does it create an obligation towards Israel to also provide fuel? This is a very complicated situation, but we have to take into account one of the most important caveats of that article that says that if that equipment will go to the adversary and not to the civilian population, which are the ones that require the humanitarian assistance, then you're allowed not to even facilitate the entrance of that. Now, Israel is allowing the entrance of food, water, and medicine, at least to the south of the Gaza Strip. There is a big question whether or not, I don't know to fact, if it allows the entrance of such goods into the north of Gaza. And if it doesn't, there is a debate, there is a question whether or not it would align with its obligations under Article 23 of the Fourth Geneva Convention to allow such aid. But for the most of it, Israel stands within its obligations under international humanitarian law to provide, actually not provide, to facilitate the entrance. Israel has no obligation of its own under that article. It should allow the ICRC to enter such goods into at least the south of Gaza. The big question, I think, it comes from statements by politicians mainly. Those politicians that said at the beginning of the conflict that the siege will be hermetic and nothing will come into Gaza, no food, no water, no medicine will enter Gaza. And that, in my view, was a big mistake by the Israeli politicians who have said that. At the same time, one could argue that for the first days of the conflict, there was no shortage, no severe shortage of food, water, and medicine, either in the north of Gaza or the south of Gaza. So for the first days of the siege, there was no urgency to let those facilities go into the Gaza Strip. But once there was such a shortage and there was a necessity to let it in, Israel allowed it to go in. So one could argue that there is such framework. Personally, I would have advised any politicians to avoid from such statements because they do not provide any help. And as we know Hamas, that wouldn't stop Hamas from operating this way or the other way towards the civilians for the benefit of the civilians of the Gaza Strip. And I would like to mention in kind of a side note that you referred to the civilians in Hamas in Gaza Strip as those of Hamas. Now, Hamas is not the official, legitimate ruler of the West Bank and the Gaza Strip. It is de facto authority of the Gaza Strip, and therefore to claim that the civilians in the Gaza Strip are the Hamas's civilians is misinterpretation of the legal reality. Hamas doesn't see any obligation that it has towards those civilians. Hamas is de facto authority there because of reality and not because of international recognition or anything like that. So while we talk about Israel's obligations towards Israeli citizens, civilians, and residents under international humanitarian law, which Israel has obligations towards them to take care of them, to protect them, to respect their right to life, to respect their rights, to protect their rights. I'm not sure that we can fully argue that Hamas has the same level of obligations towards the civilians of the Gaza Strip, just like a state, because of its status, because of its nature, because of the way it gained force on the Gaza Strip. And although we would expect it to care about the civilians in the Gaza Strip, I'm not sure that it would see it that way, that Hamas leaders would consider those civilians as their civilians. And this is a very important approach when we think about the implications of such a siege and how Hamas would react to such a siege, and statements by the Israeli politicians and cabinet members with regard to the Gaza Strip and what will be allowed to come in and what will not be allowed to enter.
Thank you. And before I move on to the Q&A, because I see we have some questions from our attendees, I have one more question for both of you. So you just mentioned that there are many politicians and many people that make statements probably without understanding what their implications are. And there have been many statements made by not only politicians, but also UN officials about the concept of self-defense. And for example, Francesca Albanese, who is the UN Special Rapporteur on the situation of human rights in the Palestinian territory occupied since 1967, that's her title. She said, and I quote, "Israel cannot claim the right of self-defense against a threat that emanates from a territory it occupies." So I would like to know what is your opinion on this kind of statement, and if does Israel have a right to self-defense in the current war? So please, Dr. Richemond-Barak.
Sure. This sounds to me like a restatement of the advisory opinion of the Wall of the International Court of Justice of 2004. Israel doesn't have the right to claim self-defense because the threat comes from within its territory. And therefore, if Israel is claiming that it's its territory, then there can be no right to self-defense against that kind of threat. There's only one little issue here, which is that Israel does not occupy Gaza. Israel withdrew from the Gaza Strip in 2005 in a very unilateral and traumatic event for the Israeli society that I believe actually was never acknowledged as for the trauma that it actually caused. And Israel left Gaza because it wanted actually to have the legitimacy. Part of the reason why Israel left Gaza was because it was the right thing to do, but also because Israel believed that if and when a threat would come from the Gaza Strip, Israel would have the right to defend itself because that would be recognized as not being under Israeli control and emanating from outside its territory. So I think this is a statement that's disconnected from reality at best and very, I want to say maybe disingenuous at worst. And I found it difficult to believe that people are not in touch with the reality of what is going on in Israel, whether Israel has boots on the ground, no boots on the ground. There is not one single Israeli living in the Gaza Strip since 2005. And it's true that Israel retained some control of the borders, but that doesn't make an occupier, according to most, if not all, interpretation of the law of occupation. So bottom line, I think that any state that is a victim of the kind of attack that Israel experienced on October 7th, murdering, slaughtering, and raping innocent civilians just for the sake of it, and intentionally, very intentionally, on that scale, that level of horror, and then to even mention that there's no right to defend itself, I don't even know. I want to get into the legal aspects of whether or not there's already a conflict with Hamas or not, which would then mean that we're not looking at the rules ad bellum, but in bello. But I don't think this is what this woman had in mind. I don't think she had in mind the ad bellum in bello distinction. I think she had in mind the fact that she wanted to negate any right of Israel essentially to do anything about what had happened, but also was very misinformed if not ignorant, about the fact that Israel is not occupying Gaza?
Yeah, I think more than that, I think there is an interview with that specific person saying that, well, Israel not only that Israel doesn't have a right to self-defense, Israel should not have resolved the situation using military force, but rather because it's the occupier, it should have used law enforcement mechanism and then address that as a law enforcement situation. Now, I would go even the different approach than Daphne said, which I completely agree. I don't think Israel is an occupying force in the Gaza Strip, but also acknowledge that there is a significant part of the international community that, including the UN and the ICRC, that says that Israel is still occupying force in the Gaza Strip. So even if we accept the notion that Israel is the occupying force in the Gaza Strip, and we take the ICJ's advisory opinion about the construction of the wall and the notion of no self-defense, neither of that means that Israel is not allowed to use military force within the occupied Gaza Strip as the occupier. The occupier is not required to use only law enforcement in the occupation, in the occupied territory. When it is facing forced military approach, armed attacks, it is allowed to use military force. International law, occupation law doesn't prohibit the occupier from using its military for armed attacks if the situation escalates to a level of an armed conflict situation. And therefore, regardless of that, I completely agree with Daphne about the fact that Israel is not occupying. Israel has the right to self-defense, putting aside the jus ad bellum question and the ongoing armed conflict. Israel has the right to defend itself. Israel has the right to defend against a non-state armed group. The notion of self-defense against non-state armed groups goes decades, if not centuries back in international law. But even in modern international law, we've seen that following September 11 events, that the international community acknowledged the right of self-defense from the US towards a non-state armed group. And therefore, the notion of self-defense against a non-state armed group exists. So the only question is the question of occupation. And as I said, I agree with Daphne that Israel is not an occupying force, but even if Israel is an occupying force, it still has the right to use military operations against Hamas. You want to call it self-defense? Call it self-defense. You don't want to call it self-defense, you say self-defense is prohibited. You want to say it's occupation? Within occupation law, it is legitimate to use force against a non-state armed group. So I don't care what she's saying. She wants to go to label it as self-defense. That's her right. She has the freedom of speech. She's a special rapporteur. She can say whatever she wants within that framework. It doesn't mean that she's legally right.
Thank you. I will now move on to some of the questions that we have from the attendees. Thank you everyone who sent the questions. So one question here is, what, if any, responsibility can be allocated to international bodies such as UNRWA, which always turn a blind eye to the creation of the Hamas infrastructure within the civilian population? New evidence make it clear that they must have known, like witness accounts, buildings explored showing arsenals, satellite imaging, video of the rockets being fired, etc. Who would like to take on this question? Dr. Richemond-Barak.
I'll just say, I'll try to go back to something that happened in the past and try to think about, what do we do with it? When Israel exposed the tunnels dug by Hezbollah at the northern border, under the noses of UNIFIL, which is monitoring that border for years, and it was clear that UNIFIL knew what was going on that border, and that Hezbollah was actually excavating in hard rock tunnels infiltrating Israel. A lot of people asked the question, but why didn't UNIFIL do anything about it? And the answer to that was, UNIFIL has a certain mandate, And UNIFIL could not actually call on Hezbollah to stop digging tunnels because that's not in its mandate. And I think that this is the kind of response that we can anticipate from UNRWA and from other, even I want to say aid organizations that were working in Gaza, that are working in Gaza, that have been working in Shifa, that that have been there extended periods of time, providing aid and trying to bring as much of assistance as they could to the civilian population there. Now, could the responsibility of these organizations be engaged? Again, we'd have to go back and look at their mandate. What is it that they can do and cannot do? Because they can only do what they can. It's the same thing, by the way. Another example of this is the ICRC. A lot of people are saying, why isn't the ICRC doing anything about the hostages? The ICRC can request again and again to gain access to the hostages held in the Gaza Strip. But if access is denied, the ICRC simply doesn't have the mandate to go ahead. It doesn't have an army, a force that is going to enter the Gaza Strip and say, okay, we're not going to look for the hostages. It is actually completely bound by the will of the belligerents, in this case, Hamas, unfortunately, a very brutal enemy. So the point is, I think we should look into this. I think that it must be, we need to think about it. I'm not saying it's not an issue. I think it's a very good question, and I'm glad that you picked it, Carolina, because I also noticed it. I think we need to spend some time thinking about how to engage the responsibility of UN and aid organizations that were active there. But every time that we've tried to do this, also in the past, beyond the examples that I gave that are related to Israel, but even in Haiti and in other places in the Balkans, sexual abuse committed by UN forces, one of the problems that international law faces is that the responsibility and accountability of UN and other UN agencies is very difficult to engage. So there's still a lot of progress to be made there, but I think this is maybe a good case study to kind of investigate and try to see if there are not any routes through which this could be done, because really there is a big issue here about keeping silent, not exposing. It's okay for civilians to be afraid of the ruling Hamas, authority in the Gaza Strip. There was another question about this. Yes, Hamas is the ruling authority in the Gaza Strip. And people are afraid of Hamas. Like I said, the people who had tunnels dug under their home, and they're not going to go and report that Hamas is using the hospital. They cannot do anything about it. They get killed for that. So they're afraid. But what about aid organizations? What about UN agencies that have a lot more space to actually expose this, what is going on there? So I think this is something that needs to be investigated, and I thank you for bringing it up.
Thank you. I will move on to another question because we have many very good and interesting questions to address. So there is another question, which is, can we call Hamas terrorists as combatants, as they don't sometimes wear uniform? We see them in civilians' clothes, and they don't carry arms openly. Dr. Rosenzweig, would you like to answer this question?
Yeah, I think it goes back again to the question of the classification of the conflict. Combatants is a relevant term only in international conflict. And again, even if it is an international conflict, then we have the question of who is a legitimate combatant. Now, this is a very interesting situation, which is quite unique to Israel, because Israel is not party to Additional Protocol 1. Now, one would consider some differentiation between the definition of combatants that appear in the Geneva Convention, the Third Geneva Convention, and the reference of who are entitled to prisoners of war status. And it goes back even, I think, to the Hague regulations to some extent, that combatants are members of an organized could be considered also members of organized armed group who are wearing the distinctive emblem or distinctive sign, carry their arms openly, and most importantly, I think above all, following international humanitarian law. And the members of Hamas and Hamas as an organization might be considered as wearing distinctive sign or clothes, because they do it from time to time, and for most of the time, they do carry arms openly for the most of their attacks, but they don't meet the main requirement of following international humanitarian law. And therefore, at least under the traditional definition of the Geneva Conventions, they are not entitled to combatancy status, and they are not entitled to be considered combatants. If we look at the more extensive approach of Additional Protocol 1, which is Articles 43 and 44 of Additional Protocol 1, they are much easier and they lower the bar of who might be considered a combatant. However, and this is a very crucial however, Israel is not only not party to Additional Protocol 1, Israel is not party to Additional Protocol 1 because of those articles. And also Article 1.4 of Additional Protocol 1, but mainly those articles. And therefore, Israel is a persistent objector to that lowering the level of who might be considered a combatant. And therefore, even if we would, and that's a big if, consider that clause to be customary law, Israel still not obliged by it. And Israel does not consider Hamas fighters, and I'm using fighters on purpose here, as combatants, as a legitimate combatants in conflict. Putting all that aside, I go back to my original claim that if this is a non-international conflict, that entire discussion is void, because there are no combatants in a non-international conflict. You have fighters, you have usually the state soldiers on the one hand and the non-state armed group on the other hand, and combatancy and combatancy immunity are not relevant to non-international conflict. So regardless of the classification of the conflict, Hamas members are not combatants.
Thank you. And so I see we're running out of time. So I will ask both of you one last question. We did this webinar to try to clarify many of the IHL concepts that we keep hearing regarding the war. So my question, if you could answer briefly, do you think that the misuse or misinterpretation of legal terms has influenced public perception or international discourse regarding the conflict? Dr. Richemond-Barak.
I don't think it has influenced the perception of the conflict. I think it's amazing to see how important international humanitarian law is to the discourse, to the question of whether it's okay to conduct a military operation in the hospital, how much people care about this evidence that needs to be provided in real time to substantiate legal and other so-called legal claims. So I think it's incredible to see the interest and the thirst that there is to kind of apply and understand these concepts, but too often they are very poorly understood. And I think it's part of our job to try to educate a little bit. So thank you for organizing this webinar.
Thank you. Dr. Rosenzweig.
I think violating international humanitarian law is a very unfortunate but useful tool for Hamas. They allowed the damage to grow. They allowed the media to see atrocities going on in the Gaza Strip. Civilians are being killed. A lot of civilians are being killed, and it affects the perspective of the international community towards that. And Daphne said at the beginning, this is an asymmetric warfare between a state, an organization, and the state see itself obliged by international law and international humanitarian law, and the non-state actor tries to use that into its advantage and create a big damage to the civilian population. Now, Ami Ayalon has published, I think it was more than 10 years ago, the notion that if in the past an armed conflict was a race to the big disaster, then he already talked about it, said more than 10 years ago. In current warfare, the race is until the picture that the media will call the atrocity, the worst picture that will come that will end the conflict. And once that picture is out there, then the media perception and the people perception is very much affected from the circumstances. And we've seen the rocket falling on the hospital. If that would have been Israel's fault, the IDF actually fired that rocket towards the hospital, that would have been the end point of the conflict. I'm certain about it. If Israel would have attacked that hospital at that time, that would end the conflict. But Israel has managed to prove that it wasn't fired by Israel. It was either misfire or directly fired by the Islamic Jihad in Gaza. And that means that Israel is allowed to continue with the operation. And this is a very big notion that goes behind the conflict between Israel and Hamas. Israel is fighting and trying to use media to explain the world how it fights in accordance to the law. Hamas, the goal of Hamas is the media, is not the actual fighting. It wants the media, it wants the international perspective. And that clash is almost always going to be in favor of Hamas within the popular media, because they will use images faster, they will use images that they can create, they can manufacture, and they don't have to prove anything, because once people see damage, they associate it with whoever they're being told caused it. Israel is operating with the media, but also with regard to other states. So as long as Israel is able to convince the US and the UK and Germany, etc., that is following international humanitarian law and that everything is done with the purpose of minimizing the damage to the civilian population, it is allowed to continue. Israel is allowed to continue with the conflict to a certain point. And the idea of following international humanitarian law to the letter means increasing the international interstate legitimacy that Israel received, because in the popular media, it's almost a lost battle from day one because of the modus operandi of Hamas and the lack of ability of Israel to respond that quickly to fake news.
You know what's actually remarkable, thinking about what you just said, Ido, is that the greater the violations, the more abject the violations, and the attack of October 7th brought Hamas so much support. And Israel's attempt at making a case, and even if it's not perfect, right? It's never perfect, but the attempt at taking precautions, making a case, and still causing a lot of human suffering, all taken into consideration, right? But that brings Israel only criticism and lack of support. And yet Hamas, which is known as a terrorist organization that threatens its own people, that commit these atrocious crimes, and then they are being trusted and they are getting the level of support. So the greater the violation, the greater the amount of support, and yet the greater precautions, again, without achieving perfection, are causing Israel a lot of trouble on the international stage. It's really interesting to see this contrast. I think we've never seen it on that scale.
Thank you. So to conclude, I would like to thank our esteemed speakers, Dr. Daphne Richemond-Barak and Dr. Ido Rosenzweig, for sharing your invaluable insights. And also I would like to thank our engaged audience for all of your questions. You feel free to send us questions that maybe we weren't able to address, or if you have any more questions. So I hope today's webinar has clarified how international humanitarian law applies in the current conflict. And thank you all for your participation in this important conversation, and we look forward to your presence in our next webinar.
Thank you.
Thank you.